Hi, everyone. My name is Hannah Redmond. I'm a labor and employment associate here in Bond's Syracuse office. I'm going to be giving a quick update on the Freelance Isn't Free Act, which is a new law that became effective on August 28th of this year, so a newly enacted statute. The Freelance Isn't Free Act, or FIFA for short, applies to freelance workers and hiring parties. Subject to a few exceptions, a freelance worker is defined as any individual who is hired to provide services of $800 or more as part of a one-time transaction or over the course of several transactions with the same hiring party in the preceding 120 days. A hiring party is very broadly defined as any person who retains a freelance worker to provide services. Importantly, local, state, and federal governments are excluded from the definition of hiring party. The Act has two main requirements for hiring parties to make sure that they are aware of. The first and probably the most important requirement is that contracts between hiring parties and freelance workers need to be reduced to writing. The FIFA Act specifies certain things that must be included in these written contracts, including, for example, the list of services that a freelance worker has to provide, the value of the services that are going to be provided, and the rate and method of compensation. There are other requirements that have to be specifically spelled out in these written contracts as well. That kind of goes beyond the scope of this mini video, but the Department of Labor has published a model contract that hiring parties and freelance workers can use to memorialize their agreement. So check that out. That model contract does contain all of the minimum requirements required under FIFA. The second major requirement that FIFA sets forth is that hiring parties are required to timely pay freelance workers. And so what timely payment means is either the hiring party has to make sure that they pay the freelance worker on the date specified in the written contract, or if the written contract does not specify a date certain by which payment must be made, payment has to be made within 30 days from the time that the freelance worker provided the services that were contracted for. The New York State Attorney General has enforcement authority for FIFA Act violations, and the Act also specifies that freelance workers have a private right of action so they can pursue claims or alleged claims against hiring parties in court as well. Make sure that you are up to speed on the written contract requirement, the timely payment requirement, as the law did just go into effect. And as always, please feel free to reach out to myself or any bond attorney with whom you're in regular contact for any questions regarding the Freelance Isn't Free Act.